Global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome back to Global Happenings Today YouTube channel. Right now, there seems to be conflict of interest, but one thing is certain: let the will of the Most High prevail, and that begins with Nigerians doing the needful. Well, as we speak, there have been a lot of issues. Some have been talking about the issue of 25%. David Windayin have been doing a lot of investigative journalism, and what he said right now is still not proven. We're going to give you details on that later, but right now Kenneth Okonkwo is saying a lot, and another lawyer who also seemed to know his onions also is speaking. But in all of that, we're going to find out exactly where Nigerians are placed. Things are happening, but from all indication there is more to this that meets the eyes. Well, before we go into the newspaper, kindly subscribe to our channel. Click on the right subscribe button beside it to see a bell notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube. Some top lawyers have been neutral for reasons best known to them. They're beginning to come out of their fence sitting and they're speaking up. But we'll start with Kenneth Okonkwo. Then we'll look at other top lawyers who are beginning to see the handwriting on the wall. This is Nigeria. We only have one Nigeria. So whatever fence sitting you are, you got to wake up and decide whom this day you will follow. Well, according to the news, Kenneth Okonkwo wrote, and I quote him, said the lead counsel, Dr. Levy Uzokwo, Senior Advocate of Nigeria, has screamed during the press interview that INEC is frustrating us. Till date, INEC has failed, refused, and neglected to provide us with all the evidence we need to prosecute our petition. Despite the order of court in that regard, Levy threatened legal showdown with INEC if this continues. It's disturbing that INEC should come to court to tell us to go and start searching for our evidence in the states. Does it mean that INEC does not know the law that guards the presidential election, or just sheer dishonesty and incompetence? In the issue of the presidential election, the entire country is one constituency, and the law is very clear in Section 62 of the Electoral Act that INEC should assemble all the polling units and collation centers' evidence in one national electronic register of the election results and give the CTC to any person or party on request. This INEC has shamelessly not done, despite our agreeing to pay every legitimate fee for them. Nigerians should warn INEC to do the needful and follow the law, or simply come to court and confess that they rigged the election in favor of their preferred candidate. We can't fold our hands and allow this impunity to continue. The only reason we asked for 7 weeks was to give INEC enough time to produce all the evidence. Now that we have 3 weeks, which ordinarily should be good for us, they must produce them now. Add your voice to this. Eternal vigilance is the price to pay for the survival of democracy. Now, this is coming from Kenneth Okonkwo. We'll talk about this in a moment, but let's find out what other top lawyers who have been keeping quiet for a while and watching the fence are saying in an interview. And this was what they said that caught their attention. This was quite a long one, but it's worth reading. Well, according to the news, the voting session has gone. However, Nigerians believe that the electoral process on the 25th of February was not credible and are interested in the outcome of the tribunal. The presidential candidates of the People's Democratic Party, Atiku Abubakar, and flag bearer of the Labour Party, Peter Obi, who are not pleased with Tinubu's declaration as winner, have decided to file suit challenging INEC. Now, on questions being raised with respect to the 2023 election, we took time out to ask to speak with institutional reform advocate, that's Segun Anwoshiko, otherwise known as Singerlink, and asked him some questions. These are some of the questions. He said, what's the impact of petition before presidential tribunal on Nigerian democracy? This is what he said. Any sane legal practitioner, enthusiastic or objective observer of the times will tell you that every election over the years across climes has in one way or the other the outcomes challenged by the parties that felt aggrieved, and it is within their right to do so as provided by the law. No election is perfect in the world, provided there are human elements that present vulnerabilities. In the case of Nigeria, every election we have ever had from the First Republic has been deemed fraught with rigging, violence, intimidation. Never have we had a decision of electoral body upturned at the presidential level. The reason for this is mainly for the fact that the eye of the law a president-elect has been declared through the process, and it is up to the contenders to prove that 1. The election is not valid due to the preponderance of irregularities, with the subsequent prayer for cancellation of the entire election. Not that this will not include the request of the petitioner to be declared the winner of, I think that again, note that this will not include the request of the petitioner to be declared the winner of the election he ironically deemed invalid. This would only demonstrate a chronic state of confusion and clinical delusion. 2. The declared winner of the election is not qualified to contest given the violation of the prescribed criteria in 1999 Constitution as amended, that is, he is not a Nigerian, he has been convicted by a court of competent jurisdiction of a crime within the last 10 years, he is not sponsored by a political party, and so on and so forth. 3. The candidate so elected was not validly returned as no valid votes were recorded, and so on and so forth. The above and other criteria that are not listed here must be proven beyond reasonable doubt based on the preponderance of evidence and balance of probability. In the wisdom of those that created our laws as well as other institutions or constitutions rather globally, there has never been a utopian dream of the expectation of a flawless election. So the challenge of the outcome of the election is not a dent on our democracy, but a series of activities that form part of it. This is why the doctrine of substantial compliance implicitly and admittedly holds that there must be flaws in the election, but that once there is substantial compliance, then the election should be accepted as having substantially complied with the laws, and the return should not be upset on the basis unlike or unless the petitioner can prove with substantial evidence that across the country irregularities, violence, and voter intimidation was the order of the day. They ask the question again, does the legal system of Nigeria endorse justice for politicians, or does the highest bidder wins this race? This is what he answered. I believe in the judiciary, which is the third estate of the realm, especially as a legal researcher, law enthusiast, and panelist at various tribunals on police matters bordering on human rights abuses. I wouldn't say stricto sensu in the narrow sense that the affairs within the hollowed walls of the temple of our justice system are equitable, just, and fair, but by and large, election tribunals over the years have treated cases before them as sui generis in a class of their own based on their peculiarity and uniqueness. We must admit that at this point, the level of decadence in our society and how this has impacted our institutions across the board, the place of morbid sentiment must also be understood, where elections declared in favor of some parties are deemed fair and free, and those ruled against their favor will be deemed bought by the highest bidder. So the short answer is no legal system is designed to act for or against anyone. The system is governed by the law of evidence. They asked another question. Do you see the court in the nearest future removing a rigged presidential candidate and passing the right judgment? He answered, as mentioned once before, the court acts based on law and quality of the argument and evidence of the parties proving the declaration of the electoral body invalid based on some criteria in alignment with the provision of the law. So if lawyers do their due diligence beyond reasonable doubt as backed by preponderance of the evidence, I believe rigging in election will soon be a thing of the past, with a clear understanding that justice will prevail at the tribunal or apex court. They asked another question. What's your take about the petition filed before the presidential tribunal? He said, my optimism is measured, if at all, because rather than focus on determining a silver bullet and gathering evidence and witnesses in that regard, during the election in preparation for the tribunal, a lot of time was burnt in needless propaganda and public incitement that created a scenario where the parties couldn't tell the difference between reality and fiction. The majority of the councils are focused on what they would earn from the process than advising on what works. I have strong doubt if the evidence required to prove most of the cases presented will be sufficient, and also know that the majority of the prayers will be struck out for want of diligent prosecution. There are various schools of thought at every tribunal, and their interpretation of the law differs from literalists, conservatives, and modernists. In the consideration of the golden rule, the harmonization of these views is better explored than being fixed on a single track of assumed interpretation, as often done in sporting you don't, for instance, claim the election is fraught with irregularities and at the same time pray to be declared winner in the same election. If you're claiming there is no substantial compliance to the prescribed rules as enshrined in the Electoral Act 2022, then the prayer must be for the cancellation of the election if proven. The issue with 25% in the FCT will be determined by the tribunal or Supreme Court as to proceed, but based on precedent, the FCT has no special criteria beyond being deemed one of the states in Nigeria. Do you feel there is a legal stance supporting a presidential candidate to have 25% in the FCT? He said, I don't think lawyers have to interpret the law. That remains the remit of the court, and if decided cases don't create enough illumination, the tribunal Supreme Court will clarify once again and hopefully for the last time to avoid future distractions where parties that came distant third will seek to manipulate their way into conservation with the hope to be declared winner in an election where they have no substantial national appeal. Funny. Okay, but let's look at this critically. He said something unique. I'll be very quick about it. Kenneth Okonkwo and the lawyers, the legal team of PEPT have been saying this literally. Give us the evidence in beavers. Give us the required evidence. You are a national body. You are an umpire, electoral umpire, and you are being given the mandate to supply all evidences. After all, the monies to conduct the election were duly provided by the federal government, by the governments of the country. Why are we now dilly-dallying back and forth, telling us to go down to a river state or whatever document? Come on. Now, this is the same thing that Singalink is now saying in another version, that whatever it is they will do, everything boils down on how they will defend their evidences. Now, INEC is not even releasing the evidence that Peter Obi's lawyer needs to even defend. Have you now seen the technicalities playing out? That's going to wrap it up for once of time. Let's meet in our